Hi there, I'm James Dapperty, and this is Coffee and a Case Note. So team, today we're talking about two shareholders in a company that owned and operated a restaurant. And what happens is that these two shareholders sadly don't get along as well as they would like, certainly not as well as they would have planned, and legal proceedings are commenced, litigation is commenced. One shareholder sues the other shareholder on the basis that this shareholder's conduct has been oppressive. What this shareholder says is, right, one option I'd like you to be forced to sell your shares to me. The other option I'm interested in is for the company to be wound up, okay? And those proceedings are commenced. Now, a cross-claim is lodged by this shareholder to say, no, contingent upon how these proceedings go, I actually want you to sell your shares to me, right? So on an if-found basis, so if the court finds there's been oppressive conduct, this shareholder wants to buy this shareholder's shares, and then this shareholder lodges a cross-claim to say, no, I'll buy your shares, right? These proceedings march on, and don't worry, this isn't the important bit. This is the background. These proceedings march on, and in short, the court says, no, I'm not ordering a share sale, no, I'm not ordering a wind-up, and no, I'm not ordering this share sale that this shareholder wants, right? So this shareholder did not get what they were after, this shareholder did not get what they were after. And so now we turn to legal costs. So normally what happens in litigation, or what often happens, is that costs follow the event, right? Is that the legal costs of the winner, put loosely, the legal costs of the person who gets what they want, are paid by the party who was opposing those orders, right? The winner gets their costs paid, speaking very, very broadly. And so what happens in this scenario where, well, this party tried to get a wind-up, tried to get a share sale, failed. This party tried to get a share sale, failed. The court says, well, our first thought is that each party should bear its own legal costs. But what this party says is, no. This shareholder tried to get a wind-up, tried to get a share sale and failed, and so this party should pay our legal costs. Complex stuff. So the court has to work through it. What this party says is, remember how this party wanted a wind-up? Well, they didn't get it, they didn't get the share sale, and our application for a share sale was pretty much just defensive. So the fact our defensive claim failed doesn't really matter, it doesn't really affect the outcome because it only failed because the plaintiff's claim failed. Now, what the court says is, what you don't understand is that the wind-up order would have been made because the affairs of the company were managed so strangely in relation to cash on hand, scary dealings with cash, tax, scary dealings with the ATO, with tax outstanding, and the appointment of a provisional liquidator. And what the court says is, if that provisional liquidator hadn't been appointed due to all those employee entitlements, all that tax, all that cash stuff, then this plaintiff, this shareholder, would have got its wind-up order. So what the court says, it's only because of the appointment of this provlic, this provisional liquidator, that the wind-up order wasn't made. It wasn't because the defendant's argument was so compelling. Similarly, what the court says is, while you, defendant, might characterise your cross-claim as defensive, in reality, it didn't fail because the plaintiff's claim failed. It failed on its own lack of merits. Put another way, the court said, based on all these employee entitlements, tax stuff, cash stuff, they were the reasons that I didn't order a share sale either way. It wasn't because that this claim was defensive only. So what the court says is, I didn't order a share sale. What the court says is, I didn't order a wind-up, but that was only because of the appointment of this provisional liquidator to deal with all this crazy tax, cash, employee entitlement stuff. And so that means the just and fair and right outcome is that each party should bear their own costs of that litigation, and that is indeed what happened. I hope that note assisted you, and I look forward to talking again soon over another coffee and another case note. Cheers.